case briefs, and so much more. LSData's got what you're looking for.
In 2008, the New York Supreme Court heard the case T Mortgage Corp v. Foy, which centered around the issue of potentially discriminatory lending practices. Specifically, the case scrutinized the definition of a higher-priced loan under the Home Mortgage Disclosure Act, HMDA, as one with an interest rate more than 3 percentage points above the Treasury security rate for a first-tier loan, which could warrant further investigation for discrimination. The case involved Major John K. Foy, a reserve officer who was on active duty when foreclosure proceedings were initiated against her property in a minority neighborhood. Foy had a 30-year mortgage with an interest rate of 972% and sought to reform the mortgage due to her deployment on active duty. The court granted a hearing, later modifying its decision and informing the parties that Foy might have been a victim of reverse redlining. The burden of proof was placed on the plaintiff, T Mortgage Corp, to demonstrate that the loan was not the result of discriminatory practices, using the HMDA as guidance. Ultimately, the court held that a mortgage exceeding 9% interest granted to a minority buyer in a minority area created a rebuttable presumption of discrimination. The lender, T Mortgage Corp, was required to prove the mortgage was not unlawfully discriminatory. The court acknowledged the broader implications of discrimination in lending practices, as seen in the subprime mortgage crisis, and emphasized the importance of lenders demonstrating the fairness of their loans.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.